School is a constituted body of the ICFI University Dehradun, which has been established as per State Legislation Act in the year 2003. And we are running 5-year BBA LLB honors program, BA LLB honors program, LLB 3-year, 1-year LLM, 2-year LLM, including PhD program. In addition to law department, which is the biggest department of the ICFI University Dehradun, we have 3 more departments. That's ICFI Business School, ICFI Education School, and ICFI Tech School. ICFI University Dehradun is a NAC accredited and ranked nationally and internationally for its better education purposes. In ICFI Law School, we have several active cells for the betterment of students, and CEDRAL, that is Center of Excellence, Alternate Dispute Resolution, is one of the active participant cell for which the current day lecture is organized. The base purpose is to aware the students for their future upcoming challenges so that they can think of choosing their career as this, choosing ADR as their career option, because these days ADR is the first primarily focused career option. With great privilege and pleasure, I welcome Miss Asa Gopalan Nair. Miss Asa Gopalan Nair, ma'am, graduated in microbiology and did her LLM with specialization in commercial and criminal laws. She was admitted to the bar in the year 1990, when many of the students have not born, are current students, and started her practice in the chamber of a retired High Court judge, and has been active in practice for last 30+ years. She became an advocate on record in the Supreme Court of India in 1996 and has a unique distinction of practice as a central and state government counsel in the Supreme Court of India for more than 25 years. She has a track record of voluminous cases management before the Supreme Court of India. During these years, she represented Government of India, State of Maharashtra as an additional government advocate, State of Assam, State of Arunachal Pradesh, State of Andhra Pradesh, Union Territory of Chandigarh, and State of Rajasthan. While working as a government counsel at the Apex Court, she gained vast experience in various fields of law as she handled litigation pertaining to various sectors of law, including land acquisition laws, arbitration laws, service laws, direct and indirect tax laws, telecom laws, public interest litigation, besides several criminal cases. She represented union government and and the state government in several important matters, including high-stake Vodafone cases, the 26/11 Mumbai terror attack case, the euthanasia legality case, the inter-country adoption and surrogacy case, environmental and public interest litigation, etc. Being exposed to large number of government matters, the realization of alternate dispute resolution was inevitable. Her practice area include domestic and international arbitration and mediation. She is a member of Chartered Institute of Arbitrators. Nair ma'am had an exceptional opportunity to work as a pro bono advocate and to pursue her commitment to public service by way of legal aid services, amicus curiae, and as a trained mediator in Supreme Court. She has been actively involved in organizing national and international level seminar on mediation from its very inception in India. She is also a certified senior mediator since in the year 2009 onwards with the Supreme Court Mediation Center. She has been recently appointed as an arbitrator for the Delhi International Arbitration Center. She has practiced as an advisory member with regard to policy and decision making in various laws affecting the government. She is also inducted as procurement legal expert for consultancy project for public contracts. Nair ma'am has been twice elected as executive member of the Honorable Supreme Court Bar Association of India. Ma'am will be taking the vast segment and topic of mediation with special touch on consumer dispute resolution through mediation. Ma'am, we welcome you.
Thank you so much for the introduction. And good evening to all, and thank you for inviting me here and giving me this opportunity for an online meet to share my experiences as a mediator, and more specifically with regard to consumer dispute resolution, which I'll be able to give a brief overview with regard to the Consumer Act at the end. The mediation process remains the same with regard to resolution of the dispute, but the remarkable change is the inclusion of mediation in the Consumer Protection Act 2019. So this is a welcome change to provide for protection of the interests of consumers and to establish authorities for timely and effectively administration and settlement of consumer disputes. You all must have come across some complaint with regard to consumer items that you have purchased. But my example I would like to state, you must have heard the popular Prestige advertisement. I'm sure everybody must have heard this. जो बीवी से करे प्यार वो प्रेस्टीज से कैसे करे इनकार. I had a very bad experience with my Prestige cooker. This was in the year 1997 or 1998 when my cooker blasted when I was cooking and the lid of the cooker had hit the ceiling and fallen on one side. The rajma which I was cooking, that is the pulse, which I was cooking was on my hands and face, badly burnt. The weight of the cooker had fallen somewhere else. Fortunately, myself and my family were saved. My little daughter was sleeping nearby. It sounded like a transformer blast, and our neighbors came running. After coming to my senses, I wrote a strong letter to the Prestige group and showed my skills as an advocate, because those days we didn't have this mediation process or anything. So as a young advocate, I showed my skill as an advocate. And within 3 days, believe me, they responded and I got a brand new cooker. So I was very happy. They apologized for the defective product. This was my first brush as a consumer. So you can imagine, we educated people, we have our, educative skills to, to ask the authorities or ask the large companies that, this is what has happened, this is your product is defective, and, you have to take steps. But what about the poor sections of the society? Those claims which come for a very small amount, who will be addressing those issues? These issues, after the Consumer Protection Act of 1986, it has, in the year 2019, the government has come out with a new legislation. Earlier, when we used to talk about alternate dispute resolution, it was only with regard to arbitration and conciliation. I remember when I trained for mediation in 2009, I had no clue about mediation. And I was wondering whether I heard it properly or whether it was meditation what I heard. Now, advocates with about 10 years experience and after 40 hours training program on mediation can become accredited mediators. It is a structured program. It is not the traditional way of doing mediation. We have a proper procedure to be followed. But practical experience is important to conduct mediation. So if you are a regular practitioner in the consumer forum, you can easily identify the issues. You learn each day how to resolve the dispute, and after each mediation, you become a better mediator. For advocates, mediation have become an alternate source of income. So during the bad COVID times that we have gone through, many advocates have suffered, especially the younger lot have suffered. So this is a welcome change that, mediation brings in. You all must have heard about the latest cases in recent time with regard to Ayodhya title dispute, which they have been able to settle. Jaipur royal family dispute, where the grandchildren of Gayatri Devi against the grand uncles for stake in the properties that were the royal source of income. The palace where Jai Mahal and Rambagh Palace. This was an out-of-court settlement. I have spent more than 30 years in the profession and have seen decades of old case files where we have prepared the list of dates in chronological order. Believe me, I must have started more than 100 years back, the chronological order which I have prepared as a list of dates for the court purpose. I have seen the emotions of the people in the courts, the tears, the smiles, the relief, but that is not the end. One party is happy, but the other party is in tears. Some are genuine cases, but they have lost because of lack of evidence or because of limitation, or because their advocates have not prepared and presented their case properly. Sometimes they have lost because they were not able to follow up their case because of financial difficulty. Sometimes they have lost because there are changes in law, etc. People do not realize that even if they win the parties, they know the truth. They do not realize that they have lost relationship, time, money, etc. People are so caught up in their emotions that they do not want to compromise. Awareness. Awareness is lacking with regard to mediation as an alternate dispute resolution. With the COVID situation, you can imagine the backlog of cases for the last 2 years, which has increased, and the legal dispensation system is now at its very low. I feel that it is my duty as an advocate to advise my client to go in for mediation as an alternate dispute resolution. And if he or she wants to go opt for litigation, then to be prepared for the long delay, the trauma of going through the whole process, mentally and physically, apart from the expenditure of fighting out the case. Initially, you are emotionally charged and ready to go in for litigation, but thereafter you are drained out due to the procedural delay and expenses incurred. The other day, a litigant from Bombay had come to Supreme Court to get information about his matter. He had no clue of the status of his matter. There were about 3 to 4 advocates already involved in coordination with his matter. One was from Goa, one from Mumbai, and another from Delhi. There was no coordination at all. He was totally helpless because his father, who was handling the matter, had passed away. He had to take leave from his official duties to attend to the case. So you can imagine his plight. It's often possible to avoid costly litigation or going to court by resolving issues using alternate dispute resolution. My advice is to look out for the future. There are now institutionalized mediations and arbitration centers. Now, how does it work? Alternate dispute resolution mechanism. It provides the opportunity to expand the pie through creative, collaborative bargaining and fulfill the interests driving their demands. For example, I had done a court annexed mediation wherein the hospital had challenged the National Consumer Forum judgment for medical negligence. The matter was referred to mediations. It had traveled from the district court to the state consumer forum to the National Consumer Forum and then to Supreme Court. The hospital was facing tarnished image and loss. The claimant refused to budge, and money was being spent on litigation by both sides. We were able to sit for 4 to 5 days, and within 2 months, we were able to, settle the matter amicably. And the claimant received the compensation more than what he had expected. So it's a win-win situation for both parties. Now here I will just start with a few slides about mediation, which are basics, whether it is a consumer dispute or any other dispute. Could you share the slide here? It's there?
Yes, ma'am.
First slide. This is not the first slide. Come on, the first slide. My first slide, you can now see, yes. Mediation, the next exit. We have been doing arbitration and conciliation for quite some time now. Just be there. Just a minute, just a minute, just a minute. There's some trouble. Yeah. My first slide, you can now see mediation, the next exit. Arbitration and conciliation was used commonly as an ADR method. But now, the judiciary, the government, and including the litigating public have started looking for other alternate methods because of the backlog and the delayed justice system. Can we have the second slide? Yeah. Okay. My second slide says it all. Justice delayed is justice denied, which is a legal maxim. What is the point of waiting years together when you cannot enjoy the fruits? Time, labor, money wasted, and you have gained nothing. You are broken-hearted. Some litigants, due to their charged emotions, wait for years together spending their money. In consumer disputes, for example, if the father dies due to medical negligence and the wife and the kids are in a hopeless state and in dire need of funds to sustain, it is better to go for mediation. Psychology says when you focus on problems, you will have more problems. When you focus on possibilities, you will have more opportunities. So to say, your beliefs are a magnet that create your reality. My third slide is why there is a need for pre-litigation mediation. In fact, now the discussions are going on with regard to pre-litigation mediation, and in commercial matters, we do have this pre-litigation mediations. So the next question these students might ask is, can mediation be done without a court order? Parties to the case are enabled to approach a mediation center or a mediator even without a court order in what is referred to as pre-litigation mediation to resolve the dispute before filing a case to explore the possibility of dispute resolution without court intervention. Government and judiciary has already started thinking on these lines because many of the cases can be nipped at the bud. For example, there are matrimonial matters, family disputes, commercial matters, consumer matters, property matters, child custody matters. Earlier days, when I started with mediation, some of the cases that were being referred to us from the Supreme Court was basically with regard to matrimonial matters, family disputes. But slowly, now the check bouncing cases, the property related issues, the commercial matters, consumer matters, all these types of matters are being referred. A mediator with a good experience will be able to help the warring parties. Now, even we have been getting mediations with regard to construction industries, from construction industries. And I have been advising the clients to include a mediation clause in the agreement, which can help sort out the issues at various stages. So there are a lot of difficulties in the construction industry. The consumers don't get their flat in time because of various reasons. So at every juncture, if we have like a sort of contract management where you can use mediation as a tool to solve the disputes, then you are in a win-win position. Cases which are suitable for the mediation may include personal injury, workers' compensation, commercial transactions, divorce or domestic relations, labor or community relations. And you ask and you actually can do mediation. And even you can do partial mediations also, it is my experience, so that at least one part of the issues are taken care of. The mediations wherein you do not involve evidentiary issues or any other matters, we do not involve complex procedures, you can mediate that. The fourth and the fifth slide, if you can come to the fourth and fifth slide. So if you see the fourth, and next I will just come to the fifth slide, it traces the history of mediation. Every community, country, and culture has a lengthy history of using various methods of informal dispute resolution. But the documentation is scant. Many of these ancient methods shared procedural features with the process that has been coalesced in the form of contemporary mediation. In India, as in other countries, the origin of mediation is obscured by the lack of a clear historical record. In addition, there is a lack of official records of indigenous process of dispute resolution due to colonization in India over the past 250 years. Take, for example, Mahabharata. It is an example of an early attempt at mediation as a conflict resolution tool, where Lord Krishna attempted to mediate the dispute between the Pandavas and the Kauravas. And I'm sure all of you all must be knowing about this. It may be worthwhile to recall that the failure of mediation in Mahabharata led to disastrous consequence, which the Chief Justice of India, N.V. Ramana, at his India-Singapore mediation submitted had quoted. And it was all over the newspaper. So, mediation is part of our history, mediation is part of our culture. When we go back to the traditional mediations, we can talk about Vedic times. It was approximately 4,000 to 1,000 years BC. Some of the Vedic hymns were composed at a period earlier than 4,000 BC. The early Aryans were very vigorous and unsophisticated people, full of joy for life, and had behind them ages of civilized existence and thought. They primarily invoked the unwritten law of divine wisdom, reason, and prudence, which according to them governed heaven and earth. This was the first or one of the first originating philosophies of mediation. Wisdom, reason, and prudence, which originating philosophy even now is practiced in Western countries. So, and we had in the earlier days, before the British came to India, the informal panchayats, these respected elderlies or the villagers or the mahajans were appointed as mediators. Till date, panchas or panch parmeshwar as neutral third parties are used to settle disputes. So after the British colonized a country, mediation began to be recognized as a formal and legalized ADR mechanism. Now let us come to the fifth slide. What are great leaders? Just change the slide. Yes. What do our great leaders have to say of and how proactive our leaders were? If you see the statement that Abraham Lincoln had made, he had said, discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the normal winner is often a loser in fees, expenses, cost, and time. And our father of the nation, Mahatma Gandhi, also described his experience at amicable dispute resolution as an exercise in uniting parties in his autobiography, which is the essence of mediation. Now, if you go back to our legal text, we can come to the Civil Procedure Code, which is Section 89, which was inserted by the CPC Amendment Act 1999 with prospective effect from 1/7/2002. ADR was mediation was as an inclusion, the development, how it took place. Now I have to just give a brief how entirely this mediation came to the forefront. Justice A.M. Ahmadi was the Chief Justice of India at that time, and he invited the Institute of the Study and Development of Legal System from USA to India for a national legal exchange program between the India and USA. They examined the problems of institutional backlogs in the Indian judicial system and suggested that ADR mechanism and legislative and structural reforms of the laws, bringing in new reforms would, if introduced, and it was introduced in 2002 in the form of amendment of Section 89 of the CPC. This amendment was challenged by a group of lawyers, following which the Malimat Committee and the 129th Law Commissions were constituted. In the light of the reports submitted by the committee, the Supreme Court of India, in the case of Salem Advocates Bar Association versus Union of India, made it mandatory for the courts to refer cases to the alternative forums, This case is a landmark in the development of mediation in India, and the students ought to read this judgment. Since then, the judges of the Supreme Court have contributed significantly towards the development of mediation as an ADR mechanism. So we now have mediation centers in the Karkakuduma Court Complex in Delhi, Patiala Court. Trainings were given by Justice R.C. Lahoti when he was the Chief Justice as a mediation conciliation committee was formed, and a project was on mediation was done in the year 2005. Thus, mediation as an alternative dispute resolution received significant impetus over the years through the enactment of various legislation and by the efforts of various judges of the Supreme Court. And I would be very happy to say that the national mediation, the first national mediations when it was conducted, I did the comparing for the first national mediation, the second district level, and I think 3 or 4 we had it before the entire thing settled down. So my 7th slide is, what is mediation? Come to the 7th slide. What is mediation? Mediation is a structured, interactive process where an impartial third party assists disputing parties in resolving conflict through the use of specialized communication and negotiation techniques. All participants in mediation are encouraged to actively participate in the process. So mediation is a process where all of us sit together. What is mediation? Mediation is a structured, interactive process where an impartial third party assists disputing parties in resolving conflict through the use of specialized communication and negotiation techniques. All participants in mediation are encouraged to actively participate in the process. So mediation is a process where all of us sit together. What is mediation? Mediation is a structured, interactive process where an impartial third party assists disputing parties in resolving conflict through the use of specialized communication and negotiation techniques. All participants in mediation are encouraged to actively participate.
Yes, ma'am. I think there is a problem.
Hello?
Hello?
Yeah.
Ma'am,
Should I read? Hello? Hello?
hello? Yes, ma'am.
Yeah, should I rejoin? There was some problem in between.
Yes, ma'am. Yes, ma'am. Actually, the system got hanged.
Oh, acha, okay. Can I start? Hello?
Yes, ma'am.
Yeah, okay.
Hello?
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 Yeah.
Ma'am,
Should I read? Hello? Hello?
hello? Hello? Yes, ma'am.
Should I rejoin? There was some problem in between.
Yes, ma'am. Yes, ma'am. Actually, the system got hanged.
Oh, acha, okay. Can I start?
Yes, ma'am.
Hello?
Yes, ma'am.
Yeah, okay.
Hello?
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 Yeah. Should I read? Hello?
Hello? Hello? Yes, ma'am.
Should I rejoin? There was some problem in between.
Yes, ma'am. Yes, ma'am. Actually, the system got hanged.
Oh, acha, okay. Can I start?
Yes, ma'am. Hello. मृगांशी मैम, मृगांशी मैम, आपको आवाज आ रही है? मृगांशी मैम, आपको आवाज आ रही है?
हाँ, Praveen, I can hear you.
Yes.
Praveen, I can hear you. Is
Okay,
ma'am
okay.
there? Vipakal? Okay. Sorry, ma'am, we can hear you. Praveen, please unmute all other participants.
Yes, ma'am. Yes, ma'am. Now post Asha Gopal ma'am.
Yeah. Can you hear me?
Yes, ma'am, we can hear you. Sorry for this
No problem.
interruption.
No. That's all right. Shall I start?
Please do, please do.
Can I have the, yeah, 8th slide. Can we come to the 8th slide?
Yes, ma'am. Yes, ma'am. Now post Asha Gopal ma'am.
Yeah. Can you hear me?
Yes, ma'am, we can hear you. Sorry for this interruption.
No. That's all right. Shall I start?
Please do, please do.
Can I have the, yeah, again, can we come to the 8th slide?
Yes, ma'am. Yes, ma'am. Yes, ma'am. Now post Asha Gopal ma'am.
Yeah. Can you hear me?
Yes, ma'am, we can hear you. Sorry for this interruption.
No. That's all right. Shall I start?
Please do, please do.
Can I have the,
एक सेकंड मैं उठा पोस्ट आशा गोपाल मैम.
yeah.
Slide number 8. Yes, ma'am. Please continue.
हेलो.
Yes, ma'am. आप कंटिन्यू करें.
आप इसको जरा आपका वाला मिनिमाइज कर दिया.
Yes. 8th slide ना मैम.
हाँ, 8th slide.
Yes, ma'am.
We are not able to see our this thing.
Wait.
Okay, fine. Okay, now we come to the 8th slide.
Yes, ma'am. Now 8.
Again, the same problem. Hello.
Yes, ma'am. Madam, 8th slide है.
नहीं, ये तो slide नहीं है. Yeah, this one, yeah. So we come, hello, yeah. So we come to the 8th slide. where the mediation process is, I've just put a diagram sort of with regard to the mediation process. What is the issues that we are looking at in a mediation process? First, there will be a dispute which you have to identify, which there is a dispute. Then the second one will be a preliminary mediation session. Third would be both the parties should be present for mediation. The fourth process will be parties decides to continue or not continue. The fifth part will be settlement or no settlement. And the sixth part, if no settlement, then litigation starts again. So what occurs during mediation is, in most mediation cases, the following is the procedure that we follow. First, the mediator and the parties, they introduce themselves. The mediator explains the rules and process involved in mediation. Then there is the statement by the parties. Each party has the opportunity to describe the dispute in his or her own way. Then there is an identification of the dispute. So when a file comes to us, we try and identify the dispute. So the mediator will be asking questions to the parties in order to gain a better understanding of the conflict. Then the next step, the mediator decides if you have an cantankerous advocate, then you are in difficulty. So the mediator has to smoothly ask the advocate who is creating problems to slowly leave the place, because he might interfere in the mediation process. So you have to do it in a very polished way. If he interferes too much, then you have a separate session with the parties where you exactly find out what is the problem that is going on in the family or in the dispute. So we call this as private caucus. So thereafter, we'll be negotiating. Negotiating, it is called as a shuttle diplomacy that we say in the mediating language. It is called shuttle diplomacy. That is, the parties remain where they are, but in separate rooms because of the private caucus. And the mediator moves from one room to the other to actually talk and bargain. This is a very important phase where you actually try to bring in a solution. You are just a catalyst. The mediator is just a catalyst. So you try to gather and, with the facts that has been given to you and the issues that you have mentally decided what exactly is the issues, you try to bring in a solution. But the solution has to come from the other side. You are only suggesting the solutions. You are not, it is not coming from you, but it can be a possibility that this could be a solution for you. You're just helping the persons, the parties, to decide. And then after negotiation, if they are happy with the solution, then you have a written agreement. Written agreement should have all the ingredients, and whoever are participating in the process should be written in the agreement. And these agreements can be upheld by the court also. It will be on if it's a private mediation, so that will be in a stamp paper. And if it's not a private, if it's a court annexed mediations, it will be sent to the court as the mediation report. Now, if we come to the 9th slide, can we have the 9th slide? Hello?
Yes, ma'am. Yes.
Yeah. See, there are 7 steps to mediation. The first step, choose a mediator. Like if it is a court annexed mediation, you don't have any choice as such. There's a list prepared of mediators, experienced mediators, and the control room, or as it is called, the reception, decides the mediator, because it's a court annexed mediation and the best mediator is given to you. Now, in the Consumer Protection Act, you have the choice to choose your mediator. Okay, this is the addition that has been done in the Consumer Protection Act 2019. Now, the second step to mediation is identifying objectives of both sides. You have to hear both parties. That is the first time when you meet, there will be an introduction. And then the second time, second procedure is you will be discussing about the facts. You'll be discussing about the issues involved. Now, the third will be, you will be discussing about the schedule, mediation schedule. It won't get over within an hour. You know, sometimes it takes time. So you will prepare the mediation schedule. Then you will be you will engage with the parties in a caucus, that is a separate meeting, and discuss the issues. And then they discuss with mediator. Then this is the next step, is the mediation shuttle diplomacy. And then if the mediation is settled, then it is endorsed. The agreement is endorsed. Settlement agreement is endorsed. So if it is an unsettled, you simply write unsettled. You are not going to write in your agreement, settlement agreement. Can you hear me? Hello?
Yes, yes, ma'am, we can hear you.
Yeah, thanks. So if it is a settled agreement, you will be writing all the details, which is the parties present, and all the other, all the ingredients should be involved. But if it is an unsettled one, you will not make any remarks against any party. That is the underlining of an unsettled agreement. Now, can we come to the 10th slide? Okay.
Yes, ma'am.
So mediation is all about bridging the gap. You are trying to bring in a compromise between the parties. Whatever issues are there, you are going to, as a mediator, going to, in a very sophisticated, in a new package. That is how a mediator does the work, because he or she is trained for that. And we have the 11th slide. Yeah. What are the advantages of mediation? Here you can see it's a neutral, safe, resolution-oriented. It is less expensive than litigation. There is complete confidentiality, and there is control of the outcome of your future. So whatever you discuss in the room, in the four corners of your office, of your chamber, or the mediation room, this should not go out of the room. This should not go out of the room. This is totally confidential. This is one of the main ingredients of a mediation technique. Now, can we have the 12th slide? 12th slide, yeah. Now, you must be wondering, if the mediation is being done by the parties, then what is the role of the mediator? Now, the mediator is a catalyst. She helps in the communication between the parties, which has totally broken. She tries to give the positivity with the parties have come to the mediation, and tries to highlight the positivity. Okay. And hello. Hello.
Yes, ma'am.
Yeah, can I continue?
Yes, ma'am.
Yeah. So when a party, it is a voluntary process. There is nobody putting pressure on you. It's a voluntary process. Our entire focus is to discuss about the dispute and how to. It is a confidential and structured process, and it should be mutually acceptable to all. And the mediation, the focus is on the future, that things should go smoothly, the present and the future, and you build relationship, and there is no evaluation whether right or you are wrong. You are simply trying to mediate the issues and solve the issues. So if you are carrying a baggage of the past, then it would be very difficult to mediate. So the first thing is leave your past behind and try to move forward in life. So life doesn't allow for us to go back and fix what we have done wrong in the past, but it does allow for us to live each day better than our last. Okay. So there are the panel of mediators who have, who have been trained for, whatever issues that come to in the mediation room. They reword it, they repackage it, restructure the proposals, and that's how it is presented to the other party. We have completed with confidentiality. Now, can we come to the 13th slide? Yeah. So when do we mediate? We do not. Please come to the 13th slide. Before this. Just before this one.
This is on 13th slide, no, ma'am?
Yes, yes. So mediation is a voluntary process, and you are, though there are some statute, rules, or court orders which may be required in participation in the mediation. So, and we will be discussing, during the mediation, if it's a private mediation, you will be discussing about the where to take place, where the mediation should take place, who will be present. We'll be taking note of all those things. The mediation, how the mediation, if it's a private mediation, how the mediator will be paid for, and how the mediator will interact with the party. A sort of structure will be, during private mediations, we can do that. Now, if you come to the 14th slide, you know about the Ayodhya matter. Justice Khalifullah was appointed as one of the mediators. Sri Ram Panchu is a learned mediator of India. So he
Ma'am? Priyanshi, ma'am? Ma'am, your voice is a little low. I can't hear you. Priyanshi, ma'am?
Yes, am I audible now?
Yeah, Briganshi, you are audible.
Yes, ma'am.
So may we take up the question answer round now?
Hello, Divakar. Is there any
No, no, ma'am, not from our side. I think
disturbance?
from ma'am side there is some network issue.
We are unable to hear ma'am.
I think there is a network problem from guest side. I've contacted her. She's rejoining, ma'am.
Okay. Okay.
Yeah. Hello. Hello.
Yes, ma'am. You're audible.
Sorry, there was some network issue on my end. Yeah, it's open. Yeah.
No, just close that one.
Close that. Okay. Okay. Sorry about that. So
We were on the 15th.
I think we were on the 16th slide. Could we have the 16th slide?
Yes, ma'am.
Yeah. So just remove that.
It's up there and
This disputes. There is there is this thing slide is not clear.
can you go back to the 15th slide, please?
15th slide. Yeah, 15th slide. Yes. So these are some of the things which, process of divorce mediation, we do understanding the process, the same process that we do it for all the other mediations. So when can we have the 16th slide?
Yes, ma'am.
This
Yeah.
is how you can see how the parties are fighting with each other. And then after the settlement between the parties, how we are able to, they shake their hands and go. And can we have the 17th slide?
Yes, ma'am. We are on.
Yeah. So after the parties have settled, you have to come to an agreement. And in case of divorce matters, you have to, domestic matters, I can say, you have to finalize the agreement, as soon as possible, because it is possible that that mind might change. So you have to, when the iron is hot, you have to prepare the agreement, and then they have to sign the agreement and go. So that is very important in a domestic dispute matter. And whereas in commercial matters and all, it still can wait for some time, but not with regard to domestic matters. So then this is the 17th slide. You can see the mediator's usefulness, the procedural justice, satisfaction with the agreement, confidence in the agreement, reconciliation between parties. You have to write the facts in your agreement, and that's most important. What are the terms and conditions on which you have prepared the agreement, and then their signature is important. The presence of the parties has to be noted down. Okay, so that is one. Now what the trend is with regard to online mediations. So you must be knowing the technological problems that now we have faced. So this type of technology problems are there, but still online mediation has picked up, and during the COVID times we have been able to do domestic as well as international mediation. So the advantages are that you don't have to move from one place to another, sit in your study or sit in your bedroom, and you can have your mediations done. You don't have to travel much. And yesterday, I think I was doing this pre-litigation mediation in one of the police stations, and the woman who had come there, she just grumbled, "Madam, my husband doesn't come for mediations at all. He doesn't, even last time he refused to come for mediation." So what we did was, I contacted the husband, and he said, "Madam, I am on official duty, and if I come for mediation, my salary will be cut. So but I'm ready for online mediation." So that is the people have started accepting online mediations also. So that is one advantage of the pandemic that has given us. So that is also quite good. So now we will come to the consumer protection, which is our topic for today. That is the 21st slide. If you can see, these are the agreements where important points have to be noted down. Okay, now let's come to the 21st slide. Understanding the mediation in consumer disputes. So what used to happen during before 1986, before the 1986 Act came into force, we had lots of problems. We had nobody used to actually could do anything about the consumers. So the government came out with this legislation in Consumer Protection Act, but at that time the issues were smaller. There was not many issues like online shopping and product recall, unsafe contracts. All those things were not there. It was quite less. So now after 86, we have come to now
2021. So in 2019, the government realized the problems that were going on. And if I can share my experience, when I used to go for a consumer matter to the National Consumer Forum or District Forum, we used to file matters, and we had to file 10 copies of the petition. And when we used to go there, there was no staff in the registry, and we had to ourselves pick up the files, and lot many difficulties were there. The matter never used to get listed, and there were a lot of adjournments, and all those things were going on. So now the government has come out with the 2019 Act, which is a lot of changes have been seen in that. And for that, we have seen that because of our experience from the last 30 years, there is a sea change in the consumer protection. Though they have written some clauses from the older 1986 Act, but it is a refreshing change this time. So the main important thing is they have addressed to the fact of the digital technology, increasing penetration of e-commerce, smartphones, cloud and internet. These are all the issues now we have. And ATM data leak, getting defective items, substandard, duplicate, poor quality, and unsafe products. So now these type of consumer related issues have been addressed, and due to the backlog of the cases, now we have this mediation has been put in as part of this thing. Can we have the 22nd slide, please? Yeah. So what was the reason that the act had come into force is to protect the right of consumer and provide speedy redressal for the consumer, speedy redressal for the consumer. But the fact was totally different. And we had first-hand experience that, things were not actually favorable to the consumer because of administrative reasons. And then after that, you can see that, your dress is short, and, the art deception in advertising, and the consumer, when the example which I gave you earlier with regard to Prestige, which is a very branded item. So these were all some of the reasons. And plus there was no rooms available, and, where the judges, where we could get our, matters filed, and a lot of issues were there. So these were the administrative challenges. Okay. Now, let us see the next slide. That's the 23rd slide. So there's a difference between the 1986 1986 Act and the 2019 Act. Now the consumer, so now there is a regulator that now center has come into the picture. So Central Consumer Protection Authority has come into the picture. Oh, this one. Then the complaint could be filed in the earlier, or the complaint should be filed in at the place where the seller is located. Now it is not that. You can, file it wherever you reside also, wherever your working position is. Then you can ask for compensation. Then you have that pecuniary jurisdiction. Then there is inclusive of product liability. Then the e-commerce. Most of the things have been addressed in this 2019 Act. So that's a refreshing change, and the mediation has been highlighted. So that is the best thing that has to happen. Can we have the 24th slide, please?
Yes, ma'am, we are on.
Yeah. So if you go to the chapter 5 of the Consumer Protection Act 2019, it says about mediation. The clauses relevant is empanelment of mediators. Now, in a very big way, the the government is going to empanel the mediators who have good experience and who have done a number of mediations. So this is what the empanelment is about. And nomination of mediators panel, section 76. And what are the duties of mediator? So the duties of mediators is to disclose if they have any other, certain facts that you haven't done any other work related to that the other parties, that sort of thing. So you have to disclose everything. Then replacement of you can get your mediator replaced also, but the notice will also go to before replacing the mediator, the notice will go to the mediator. then the procedure for mediation, then settlement through mediation, then the recording of settlement and passing of the order. Okay. So can we have the, and there is one judgment in Afcon's Infrastructure Limited versus Cherian Worky Constructions Company Limited, 2010 8 SEC 224 page number, and it says that the process of adjudication of consumer dispute is adversarial in nature and is characterized with numerous and complex rules of form and procedure. So filing a consumer complaint comprises of many rules and procedure, where the process of the issuance of legal notice to the opposite party and adjudication through a 3-tier consumer court is very time consuming. This we have faced earlier when, the parties would never come. The notice, we had to send notices to the parties and the parties will never turn up. So now this is also taken care of. And now if you can, mediation cell, there is going to be a mediation cell next to the, just come to the earlier one. No, yeah. There's going to be a mediation cell next to the consumer court, and then matters after the complaint is filed. If the judges, if the chairman feels, chairman goes into it, and if he feels that this is a good matter for mediation, then it is the mediation is sent to mediation, and then there is a refund fee, which is the clause 5 in the 2020 mediation rules. Then the resort to arbitral or judicial proceeding, settlement agreement. These are all some of the things which have been covered in the rules 2020. Can we have the slide? This is the last slide. Last slide. I think this is the last slide.
Last slide, ma'am.
With regard to the regulation. Okay. So we have the regulation 2020 also, code of conduct and mediation proceedings, role of mediation, all these basics that which we have covered in the earlier part. This all things are there. Then the changes, there has been a lot of changes in the protection, Consumer Protection Act of 2019. Now, so I've covered all those things. Now, what we can conclude is that, we can actually go through a lot, but now the conclusion which we can gather from this is growing backlog and delay in resolution of consumer disputes can erode the consumer's trust in the legal system, where the claims are of small value. You won't believe it. There are claims which are of 5,000 rupees, 10,000 rupees, which come to the consumer court. And, the number of cases that come there. Mediation can play a very important role in consumer dispute resolution, especially in cases which are pending for more than 5 years in the consumer court. In comparison to the complaint filed in the consumer, mediation can take away a lot of burden from the consumer and be quick, private, fair, and inexpensive, thus strengthening and consensual alternatives. So I feel when the economy is growing, mediation has been playing a very important role and will be playing a very important role with regard to consumer related issues and various other issues. So that's it. Thank you so much. I'm sorry for all the problems that we face.
So technical part is not in anyone's control. So these are the part and partial of these days events. I know. It will still take some time, but mediation is here to stay. And I would advise, it also, it has become, your personality changes if you do mediation. You become a little more, understanding of the problems. And I would advise the students that you should undergo the 40-hour training program, and you will understand the essence of mediation, though you will have to put in a number of years, at least 7 to 8 years, at least I would say, to understand really the intricacies of, each field that you are entering in. That's my advice to the younger lot. Thank you, ma'am. In fact, in our 5-year BBA LLB honors program and BA LLB honors program, we have a separate honors specified honors course in ADR only, because these days the students are more inclined towards this particular field.
And another thing what I found is, all law students are not so very aggressive, and they would prefer to do chamber practice, and some of them would be very, would have the argumentative skills. Some people have the research skills. So for those students who have the research skills, and who are not very loud, and not very expressive or in type of students, they can actually get into mediation, because it's a very calm, composed, very homely atmosphere where you really love that, that sort of atmosphere. So
Right, ma'am. Right, ma'am. That's very nice lecture. Mriganshi, ma'am, over to you.
Okay, thank you, sir. Ma'am, it was a really nice experience listening to you. Pleasure. And do we have any questions from the participants? If you wish to ask any question from ma'am, please do use the chat box, or you can unmute yourself.
I think ma'am has clarified all the things in every aspect.
Yes, that is right. No
I'm
worries.
glad, otherwise I might have get a bouncer from these students. They are quite smart nowadays.
Yes, ma'am.
All right, ma'am. Then I request Dr. Sushant Sarangi, sir, Associate Professor, ICFI Law School, to please propose the vote of thanks. Over to you, sir.
Sarangi, sir. I think he has lost the connection. I think.
Okay,
Okay, Divakar.
I'll invite Assistant Dean, Dr. Monica Corolla, ma'am. Because of certain urgency, she could not join earlier. Ma'am, are you there?
Yeah, I'm there,
Yes, over to you, ma'am.
Mriganshi. I hope I'm audible.
Yes,
Yes,
ma'am.
ma'am.
Yeah, sorry, I had some problem connecting to the link earlier. So, ma'am, it's been wonderful listening to you. And mediation is one of the field where students can, do very well. And as you rightly said, that it needs a certain kind of your ability, in the sense that if students are of certain nature, they'll be able to excel in that field. And there are many students like that who are from they have this ability to be able to connect with people. So in mediation, I'm sure that those students who are able to connect with people, they'll be able to bring out the best agreements between parties. And it's a wonderful field in which they can master. And since even internationally it's going to become one of the most important means of resolving disputes, it will open many avenues, more so in the coming days. And ma'am, it's been a privilege to hear to you, and you have wonderfully explained the methods of how mediation can be done, the steps of mediation, and how even pre-litigation mediation is able to solve a lot of problems. So it's been wonderful, and we are thankful to you on behalf of the ADR cell and on behalf of ICFI University. We would like to thank you and welcome you whenever you are in Dehradun to come to the university to teach our students, so that we can make learning more effective.
Thank you so much for the invite. I would love to.
Thank you. We also would like to thank Divakar sir, and also Mriganshi ma'am, who has coordinated this, and Monica Kotyal in her absence. I think Sadangi sir is saying that his mic has been muted. So please just see if it can be opened. He was waiting to probably give this vote of thanks. But since it so happened that his mic did not work, I have been able to give the vote of thanks. But in case he can speak, sir, can you open your mic? Your word of thanks also to ma'am would be great. Hello? Okay. Okay, sorry, we can't hear.
Some problem with that side. Yes, sir. Yes, ma'am.
Oh, okay. So, ma'am, thank you very much for this and for being a part of ICFI Law School. We look forward to you to training our students and to helping us make them good lawyers and good mediators. Thank you, ma'am.
Okay, fine. Thanks. Thanks a lot. Thanks, everybody.
Thank you, ma'am. With your permission, may we end the meeting, ma'am?
Okay, thank you. Yeah, we can.
Okay, thank you, ma'am. Thank
Thanks.
you.